Yes, good morning, everyone.
Good morning, sir.
We are continuing our lectures on petroleum law. Our focus is on decommissioning and abandonment of petroleum installations. Today is the 16th day of June 2023. And because of time, I will not go through all I went through yesterday. We'll tell you about what decommissioning entails. You may want to do some further reading on that. Because of time, we will jump into the legal regime for decommissioning. I already told you what it is. I told you the environmental and economic implications for a government failing to, for a company failing to decommission an infrastructure, and there could also be some societal implication as well. And so let's jump into the legal regime. For the legal regime, of course, you know that petroleum, based on what we looked at in the first semester, littoral states, or what you call coastal states, do have rights, certain rights to extract and develop petroleum resources that are located either within their exclusive economic zones, continental shelf, or territorial sea. You remember?
Yes, sir.
And we pointed out that all of these areas are parts of the sea, and to some extent they are regulated by the law of the sea. What this means is that even though international law recognizes that a coastal state may have these rights, it still enjoins them to comply with certain regulatory obligations that are geared towards ensuring that the exploitation of those resources do not have inimical consequences or negative consequences for the environment and for other users of the sea and for other users of the sea. And so in that regard, certain aspects of the conventions on the law of the sea have some bearing on decommissioning and abandonment. Are you with me so far? So for example, Article 5 sub 5 of the Geneva Convention on the Continental Shelf, Geneva Convention on the Continental Shelf, is to the effect that any installations that are abandoned or disused must be entirely removed. Any installations that are abandoned or disused must be entirely removed. That is the Geneva Convention, which, like you know, was among the 4 conventions that were issued following that conference that was held in that same year. Certain drawbacks we want to note with respect to this regime, however, is that it is silent on specific installation materials such as pipelines. It just said any installations which are abandoned or disused must be removed. From an oil and gas perspective, we would have wanted it to be more specific. So it's a limitation that it is silent on the installation materials that are to be removed, such as pipeline. Again, it fails to provide the definition of the word any as part of the infrastructure to be detached. It fails to define what do you mean by any. We would have wanted to see a list of these installations that you intend to refer to. And again, that convention, perhaps the third limitation is that it does not, or it did not specifically place obligations on oil firms with respect to the protection of the offshore environment. Perhaps you may want to also add a third one, that it did not specifically place or impose obligations on oil firms with regard to the protection of the offshore environment. Then there was also the London Dumping Convention of 1952, or what you would call the Convention on the Prevention of Marine Pollution by Dumping of Waste and Other Matter. Convention on the Prevention of Marine Pollution by Dumping of Waste and Other Matter, also called the London Dumping Convention of 1972. So while that convention itself doesn't specifically deal with decommissioning and abandonment, there was a protocol that was issued in pursuance to it. You know, like we have statutes, and then we have subsidiary legislation. Example is a regulation. Is that not so?
Yes.
Yes, or a rule. In international law, when we have a statute, the subsidiary legislation is called a protocol. Are you with me?
Yes, sir.
You look at it more in the final year. So that convention, the London Dumping Convention itself, doesn't deal with decommissioning and abandonment. However, a protocol was issued in 1996 under that convention. And the protocol deals with all aspects of dumping on the seas. Basically, this convention has to do with dumping. You know that some countries could go to the high sea and dump things. In those days, in the United States of America, if the economy, the wheat harvest is more than what they anticipated, instead of them to send the surplus to African countries where people are dying of hunger, they will take it to the middle of the sea and dump it. Are you with me? Yes, so this convention basically deals with how to ensure that in the course of dumping, they do not pollute the environment. So the prevention of marine pollution by dumping of waste. And so the protocol, the 1996 protocol, deals with all aspects of dumping on the seas. And among other things, it defines dumping, please listen, as any abandonment or toppling at site, of platforms or other man-made structures at sea for the purpose of deliberate disposal. Any abandonment or toppling at sea of platforms or other man-made structures at sea for the purpose of what? Deliberate dumping. And under that protocol, it is illegal to abandon a crude oil platform or any aspect of it at sea. It is illegal to abandon a crude oil offshore platform or any aspect of it at where? Sea. Another regime I want you to note again is UNCLOS, United Nations Convention on the Law of the Sea of 1982. UNCLOS of 82. Thank you, Lord. UNCLOS, Article 208 of UNCLOS. Article 208 of UNCLOS mandates state parties or requires state parties to adopt laws and regulations, including several other desirable measures to prevent, 1, reduce, 2, and control pollution of the marine environment arising from or in connection with seabed activities subject to their jurisdiction. Please ensure you get this recording so that you can adequately capture most of these readings into your notes. Remember that the note is 5 marks, and while you are writing, you are reading. That is why I'm asking you to write your notes. It's not because you don't have what to do with your time, but anybody who faithfully reproduces this lecture into a note coupled with other readings he will add, will not have a problem passing this course. Are you with me?
Yes.
Under Article 60, again I will read because of the space. Article 60, sub 3 provides that due notice must be given of the construction of such artificial islands, installations, or structures, and permanent means of giving warning of their presence must be maintained. Due notice must be given of the construction of such artificial islands, installations, or structures. That is all. Notify us of these installations. Are you with me? And then ensure that you put in place a permanent notice strategy. Permanent means for giving warning of their presence must also be maintained. Any installations or structures which are abandoned or disused shall be removed to ensure safety of navigation, taking into account any generally accepted international standards established in this regard by the competent international organization. Such removal shall also have due regard, please listen, due regard to fishing, the protection of the marine environment, and the rights and duties of other states. Are you with me? That removal, please, what is it? The removal must also have due regard to fishing, protection of the marine environment, and rights and duties of other states. Appropriate publicity shall also be given to the depth, position, and dimensions of any installations or structures not entirely removed. See also Article 80. So, first, notify us when you are putting an installation. That is the first thing. 2, if you are done with your work, ensure that you remove every structure that you abandon. Remove them for the safety of the environment, and in so doing, have regard to fishing, have regard to the rights of other states, and also have regard to the need to protect the maritime environment. Are there questions? Can I take a question? Any question? Okay. So let's look at the Abidjan Convention, 1981. We are coming home now. The Convention for Cooperation in the Protection and Development of the Marine and Coastal Environment of the West and Central African Region. Again, under this convention, state parties, Nigeria is one of them, are obligated to take actions to stop environmental pollution and to mitigate all forms of pollution consequential to the seabed and subsea, occasioned by crude oil exploration and production activities. Just to point out that this convention doesn't specifically mention abandonment or decommissioning, but that notwithstanding, it mandates states to take measures to protect the environment and to mitigate all forms of pollution. Are you with me so far?
Yes, sir.
So to that extent, you can stretch the convention to say that it also mandates states to put in place adequate measures for effective decommissioning and abandonment as a means of ensuring that the human environment is not damaged, particularly offshore. Now let's look at Nigeria and see how far we will go. Is that okay?
Yes, sir.
By way of introduction, there are an estimated 200 offshore oil structures located in Nigeria's maritime zone alone, like maritime. Under international law, it is Nigeria's sovereign right and responsibility to safeguard and preserve the marine environment. But thus far, no evidence exists to substantiate that the decommissioning of crude oil facility has ever taken place in Nigeria. So we have been producing since 1956, and we've had installations as far back as the 30s. Eventually, we discovered petroleum in Imo State in the early 50s, and ultimately at Olebri. Since that time till now, despite all the installations that are put offshore and onshore, we do not have any record that any decommissioning has effectively been carried out. Are you with me so far?
Yes, sir.
The argument, of course, from the perspective of the oil companies is that these installations have not reached the end of their life. They have not got to the end of their operational lives. Some people are arguing that the average pipeline in Nigeria is over 50 years. And as such, they have, they are out of date. What word will I use? And they have become moribund. Are you with me? Yes, they should not be used. But oil companies, in order to minimize costs, continue to use them. And for such person, that is one reason why we have regular rupture of pipeline. If you take that to the oil company, they will say no. There is no standard rule or law on how many years a pipeline can stay. Are you with me?
Yes.
It depends again on the environment. A pipeline that is set up in a very, very salty environment will likely corrode faster because salt corrodes. Is that also?
Yes.
Than a pipeline that is set up in an area that doesn't have so much salt. So for them, they could say the 60 years we are saying or the 70 years we are saying does not necessarily mean that it's time for them to abandon and then decommission these installations. Because for them, Nigeria's oil wells and rigs have not got to the end of their operational lives. That notwithstanding, any reasonable government ought to ensure, in the course of making laws, ought to ensure that they cater for this eventuality, because it is something that is not, you cannot avoid it. One way or the other, oil companies, can you take this back a bit for me? Thank you, my friend. Thank you, Lord. Whether you like it or not, one way or the other, oil companies operating in the country at some point will stop to operate. Is that so? Is that so?
Yes,
yes, it is estimated that in the next 41 years, we will stop producing, or anybody who is sleeping, I won't call any name because you're on record, kindly stand up. If the thing has come, it's not an offense for it to come. It happens to all of us. But just take your stand so that it's clear. Can we continue?
Yes.
Yeah, so it is believed that at current rate of production, if we're producing 2 million barrels daily, or 1.8, in the next 35 to 41 years, our production should end. And if that is the case, the next thing we'll start to look at is how do we ensure that these installations do not continue, and then we restore the community and the environment back to how it was for the benefit of the original landowners. Is that also?
Yes.
But surprisingly, like I said, any government that has vision will not necessarily wait for the problem to happen to legislate. They have to legislate in advance. And so even before we came to the PIA regime, there were provisions for decommissioning. Are you with me? Yes, and abandonment. Decommissioning was not provided for in detail, but you can still see some reference to, or you could infer that it was referred to under the Petroleum Act regime, particularly Regulation 36, subsection 1 of the Drilling and Production Regulations, which provided, among other things, that no borehole or existing well shall be re-drilled, plugged, or abandoned, and no cemented casing or other permanent form of casing shall be withdrawn from any borehole or existing well which it is proposed to abandon without the written permission of the Director of Petroleum Resources. Now you can look up, we know that we told you that the oil and gas industry is heavily regulated, It is not a regime, it's not an industry that people can do anything they want to do. At every point in time in the operations of an oil company, you are going to require certifications from the regulator. Are you with me? Yes, permit. You want to buy equipment, you go for permit. You want to clean the environment that was polluted, you need a permit. You want to erect an infrastructure, you need a permit. You need local content permit. You need all manner of reports and permits and certifications are required, so that the regulator will be on top of the game, on top of his game, to know whatever is happening in that sector. Are you with me so far?
Yes.
So, Regulation 36 sub 1, no borehole or existing well shall be what re-drilled, plugged or abandoned, number 1. And 2, and no casing or other permanent form of casing shall be withdrawn from any borehole or existing well which it is proposed to abandon without the written permission of the Director of Petroleum Resources. He cannot give the permission the way he wants to go and do it. He has to write it what? He has to write down his permission and give it to the oil company. Thank you. Sorry for the stress of Tarila.
Yes, sir.
Sub 2 of that same regulation says every borehole or existing well which the licensee or lessee intends to abandon shall, unless the Director of Petroleum Resources otherwise permits in writing, be securely plugged by the licensee or lessee so as to prevent ingress and egress of water into and from any portion or portions of the strata bored through, and shall be dealt with in strict accordance with an abandonment program approved or agreed to by the Director of Petroleum Resources. So the whole idea is that don't start any form of decommissioning, and any well you are abandoning, you must securely plug it so that we're not here tomorrow that fuel is leaking out. Is that not so?
Yes.
Or gas is coming out. Securely plug it. Why? So as to prevent ingress and egress. Ingress simply means coming in, egress means going out. So you have seen it in land law. Have you seen that word? No. Okay, we used to use it in land law. Ingress and egress of water from any portion of the strata board. That is the first thing. That is the first thing. Can we continue, please?
Yes, sir.
Section 46 Regulation 46 subsection 3 also has some bearing from which decommissioning can be inferred. It has some bearing or some provisions from which decommissioning can be inferred, even though it was not specifically mentioned in the body of the Act. And I will read. The licensee or lessee shall, within 2 months or such further period as the minister may approve after the termination of his license or lease, number 1, deliver to the minister in good order, repair and condition, and for further working, all productive boreholes or wells or wells in brackets, unless the Director of Petroleum Resources requires the licensee or lessee in writing to plug them as he may direct, or as provided by the regulations, together with all casings and other appurtenances to the boreholes and wells which are below the Christmas tree and cannot be moved without causing injury to the said boreholes or wells. Are you with me so far?
Yes, sir.
So first thing is that the license holder or the lease holder, after the termination of his lease, is now to go up to the minister and defend and deliver to him in good order, repair and condition all the wells. I'm coming. All productive boreholes or wells. You have to take it back. It's still producing, but I am abandoning it because probably my tenure has terminated. I want to move on. Then ensure that when you bring in the minister to take charge, all the borehole, productive boreholes or wells are to be in good what? Condition. Number 2, the same time Regulation 6 provides that the license holder is to fill up and fence all holes other than boreholes and wells. Every oil pipeline, every well or any hole that you bore, now that your tenure is over, you have to fill it up and then fence it. Why do you fence it, Ayla?
So please come again.
The law is saying you have a license, 20 years or 15 years, it's over now.
Yes, sir.
You want to move on. But in doing that, all the boreholes that you have opened, you must plug them.
Yes, sir.
Plug it more like use a cap to cover it. Is that not so?
Yes, sir.
You must plug all of them, and then you must fence them as well. Of course, fencing is for security now.
Yes, sir.
Because you are now abandoning it, you will not be around again. The mopo moving around with you too, they will go back to base. You know. The next one is that the license or leaseholder, we are still on Regulation 36, must take reasonable steps to restore the environment to the way it used to be. No. Take reasonable steps to restore the environment. So the obligation to restore the environment does not only apply when there is an oil spill. Are you with me?
Yes.
Yes, that is not the only time when you have the obligation to restore the environment. When you are done with everything and your tenure is over, you must also take reasonable steps to restore the environment. That means that even upon termination, you may still have obligations. Is that not so?
Yes, sir.
Restore to the original condition the surface of the relevant area to and all buildings and structures thereon which have been damaged in the course of its operations. Section 46 subsection 2 now provides that 2 months after the termination of his license, he shall plug every borehole which the director may indicate in the manner specified. Lastly, after the termination and subject to the rights of the owners of the surface or other groups having a legal interest in the relevant area or any part of it, he must remove, that is the last one, remove all buildings, installations, chattels, and effects that you've erected. Remove every building. So if you go to, how many of us have gone to Izimiringi now from the Tombia Junction? Yes, if you are going, you see all those infrastructures now. Those you've seen them, those Navy people or soldiers, they have some small houses. Is that not so? Then they have what you may call a flow station. All those infrastructure, when they are finally leaving, they have the obligation to do what? Dismantle them. When they dismantle them, they may recycle it or they may sell it. The law even provided that the minister may buy any such buildings, installations, work, chattel or effect at a reasonable price. The minister of petroleum can say, that thing you want to remove, don't remove it. I have use for it. On behalf of the government, we will be paying you 30,000 naira. The price must be reasonable on both sides. Are there questions? Are you sure? Okay, let's continue now. So, next we want to look at now is the Petroleum Industry Act and decommissioning. That was the old regime we just looked at. Remember that a PA is being phased out. It's a regime that is being phased out. And I said that it did not provide for decommissioning, although you may infer it from Regulation 46. Are you with me?
Yes.
Yes. So for the decommissioning and abandonment in the Petroleum Act of 1969, your focus should be Regulation 36 and then Regulation 46. Is that not so? Now let's now come to the PIA. You all know about the PIA. Now it was enacted in first semester. We talked at length about the environmental provisions that are contained in that act, and we also pointed out that now an oil company that has been granted a license is to submit an FDP, a field development plan. Is that also?
Yes.
Instead of that FDP, the FDP itself contains miniature plans, a lot of sub-plans. Plan to manage the environment, plan to address your local content obligations, plan for decommissioning. Are you with me?
Yes, sir.
Yes, so that idea is still brought here that the holder of a concession may seek to decommission his facility, or he may be required to do so by the regulator in certain instances. Are you with me?
Yes, sir.
Yeah. For decommissioning, remember it is not only an offshore matter now, it's offshore and downstream. I mean, it's upstream and downstream. Are you with me?
Yes.
It's not only upstream, even downstream. A refinery, for example, you know, Dangote has built something around Lagos. How many of us are aware of it? Yes, so if you go there, you will want to see a massive complex. Is that not so?
Yes.
There will be pipelines, there will be this, there will be that, and all that. So any legal regime that we want to bring would want to cater for some of these concerns as well. So you know that the NURC, the Commission, regulates upstream, and then the downstream regulator, midstream and downstream, the authority. Is that also?
Yes, sir.
Covers midstream and downstream. In either case, if it is upstream, for you to decommission, you must get the permission of the regulator. If it's midstream and downstream, the same thing. I don't know if you understand.
Yes, sir.
Yes. So under that, for decommissioning, you want to look at sections 232 and 234. 233. Thank you, Lord. Mm-hmm. So remember two things. The regulator may say, "Oga, decommission." The company may write and say, "Oga, allow us to what? Decommission." Either way, when you are doing it, it must be conducted with good international practice, good international industry practice. My colleague, my colleague who is now a judge, Simon Amadoboa, in the High Court, he has pointed out in one forum where we all met to discuss this matter, that why is PIA using the word good international standard? Why not best practice? Are you with me?
Yes,
That what they should have used should have been best practice, best international petroleum practice or standards, and not just telling us good. So that he feels that there's some mischief in that regard that should have been addressed. Okay, so it must be conducted in accordance with good international petroleum industry practice and comply with the guidelines that either the commission or the authority may issue. Of course, when we mean guideline, it could also embrace regulation. Are you with me? Are you with me?
Yes.
So the NURC can now issue a regulation to say, if you want to do decommissioning, comply with this. In that regard, we have two new body of laws. Of course, there are subsidiary laws. For the purpose of recording, I will just again state it. Upstream decommissioning and abandonment regulations. Upstream decommissioning and abandonment regulations. In the same vein, we have the midstream and downstream decommissioning and abandonment regulations. In either case, they are all made in pursuance to sections 232 and 233 of the Petroleum Industry Act. I'll just try and give us a summary, then we'll try and look at the specifics. Is that okay? Basically, the law is saying that before you decommission, you can't do it alone. You need authorization. And then you can proceed. In doing that, you want to be sorry, your boss. Bolo Konkumo, my brother. Before you do that, you must be conscious of the environmental and societal implications. Are you with me?
Yes, sir.
That, in a summary, is what it is. Then I told you that of late we've had issues with companies divesting, selling their shares. Companies that have operated in the Niger Delta for so many years are suddenly saying they are going upstream. They don't want to. They are going offshore. They don't want to be downstream, and for and swamp and land. And for them, their main excuse is security. But environmentalists have argued that these people are doing this to avoid their own obligations. Some of them know that very soon the decommissioning will start, because most of these pipelines or these fields are becoming very mature. Are you with me? Yes. Some know that in the next 10 years, 7 years, 8 years, we'll start talking about decommissioning, and that can bring another wahala, because I told you that decommissioning and abandonment is very, very, yes, the cost implications are also very high. And so to avoid such wahala, they are quickly selling their assets to Nigerian companies like Seplat and a number of these companies, and them, they are very happy. Somebody who has not seen money all his life, you call him and give him 100,000 naira, will be very happy. So a Nigerian oil and gas company that buys a concession from Shell and you start to produce, even if you're making 40 million naira every month, you'll be happy as a person. Is that not so? Yes. But these international oil companies, their profit is in mega billions of dollars. The moment they are not able to hit that level, what are we wasting our time in Nigeria? So it's easy for them to have people to buy these concessions, because Nigerians are excited. Everybody wants to have an oil block. Sometimes you don't even know what you are buying, but that excitement is there. How do we ensure that a company that does that to avoid its own obligation is brought to book or is held to account? Those were things that have been a concern for many scholars in the past. And now Section 232 of the Act has now dealt with it. Are you with me? Yes. Section 232 now deals with the fact that you cannot run away from your obligation. Then Section 233, as we are going to see now, also provides for a fund. And that is one of the, I think, the beautiful things about the PIA is that it has a number of funds, where companies will now be mandated to make annual contribution to. So we have given you an oil block, you may go and produce oil, you have 20 years, and then we don't have to wait for the expiration of the 20 years to say, you may bring money, let's decommission. No, from day one, as you start to make profits, you start to contribute money to the fund. Are you with me so far? Yes. And then the fund will continue to accumulate. When it's time for you to decommission, you will come and collect your own money and go and decommission. If you are dragging your feet, then we'll carry that your money and give it to Kuro, and she will decommission. Are you with me so far?
Yes, sir.
In a nutshell, this is where we are today. But for purpose of my recording, I want to try and see how we can go through portions of this section. They are quite long, but God will help us to see what we can do within the time frame that we have. Thank you, Lord. So, who is responsible, first of all, for decommissioning and abandonment? Who is responsible for PSCs, production sharing contracts, service contracts, and all that one? For a PSC, you have the concessionaire, and then you have the contractor. Is that not so?
Yes, sir.
My daughter, explain the PSC for me. Victoria. Yes, how is it done? How is the arrangement of law?
Okay. In place, when the concession is given, they come together, the contractor and concessionaire.
Yes.
And they share the profits based on oil and money.
Yes, and then oil company, the contractor usually bears the cost and the risk associated with the venture. Is that not so?
Yes.
In the event that oil is covered, then he's allowed to deduct the costs that he expended upfront. He will deduct those costs, and then after that, we start talking about sharing profit. Is that not so? It will appear, just that I think it is not elegantly drafted, but it will appear that under section 232, for PSCs and ROSCs, the responsibilities relating to drilling and decommissioning and abandonment will apply to the licensee or lessee as a contractor. I don't know why they use the word as a contractor. Let me read it for us. So let me see if you can make sense of it. Okay, so let me just read. In production sharing contracts or any other contractual arrangement pursuant to section 84, subsection 2 of this act, responsibilities and liabilities relating to decommissioning and abandonment are specified in this section, and section 233 of the act shall apply to the licensee or lessee as contractor. I don't know what that means. It shall apply to the licensee or lessee as contractor. Can somebody give me any idea what you think that means? Because if we say licensee or lessee, if you say licensee, are you with me so far, my friends?
Yes, sir.
What happens is that we have the licensee or the lessee who now brings in a contractor to develop that concession. Is that not what happens? Yes, he bears the costs and then he bears the obligations. If we find oil, then we'll talk about profits. But the PIA is now saying that the responsibility for decommissioning and abandonment will apply to the licensee as contractor. But the licensee is not a contractor. He is giving the concession. He calls Peroway to say, Tarila, to say, Tarila, you have the technical capacity. Go and develop this field. Bear all the costs. When you find oil come, then we'll now start talking about deductions and eventual profit sharing. When you are now saying that responsibility shall be imposed upon me as contractor, are you saying, please listen, are you saying that the contractor who is Tarila now Nigeria Limited will not bear the responsibility for decommissioning and abandonment? Are you saying that it is only me, the concessionaire, the licensee or lessee, as the case may be, that will bear the responsibility? If that is so, why do you use the word as contractor? Why not say the licensee or lessee to whom the concession is granted will be responsible for decommissioning and abandonment? That is easy and straightforward. Did they intend to say that in PSCs and ROSCs, the responsibility for decommissioning and abandonment will be borne by the contractor? Would that have been the intention? But they have made a mistake because the PIA is riddled with mistakes. Just like Kama 2020. We're all human beings, nobody is above mistakes. But for a document of this nature, they should have been able to, and they have the money, they have the resources. The document should have been able to go through 4-5 eyes. 4-5. Are you with me?
Yes.
First edition, you go through. So they have the money. How much will you pay? But again, people are not ready to work in Nigeria. Everybody wants to eat. Teachers that they send to go and teach children refuse to teach. Lecturers will not come to teach. Civil servants will not go to work. So it's an endemic problem. Doctors will not go to work. They have their private hospitals. And the time people go there for treatment, doctor is not there. If you give him a query, you can send people to come and kill you. Or if he has political connections, he can warn you. Is that not so? And suspend you, because he can persecute you. And I don't know whether that is why we are having it. But I just felt I should point that out to you. Gemi, are you okay? You are okay. Should we off the AC? Off it. Okay. Please, can we continue? So first of all, know that under section 232, all onshore installations are to be completely removed. That is the first of all. The Act imposes an obligation, are to be completely removed, and the environment is to be restored, completely removed, and then the environment is to be restored to its former position. Of course, when we mean restore, we mean as much as possible. Is that also? Yes. That is subsection 7. Onshore installations and structures shall be completely removed, and the environment is to be restored to its original condition, except for buried transportation pipelines and gathering lines. What comes to my mind is why I say onshore installations. What about offshore? What is the reason for singling out onshore? Are you with me? Why onshore installations? Why not offshore? Are you saying offshore installations, we are to keep them there? After all, international law has already imposed an obligation on us to remove all offshore installations, or to ensure that we put in place permanent warning systems to prevent the pollution of the environment and to ensure the safety of navigation. Why not extend that obligation to oil companies operating offshore? Remove all installations as much as is possible. Are you with me? Remove all installations. If, however, it's not possible, come for some permits or exemption. It's better that you put a blanket obligation and keep room for some exemptions than not to provide any obligation at all in that area. Are you with me so far? Yes. Okay, so now before the company itself will start the decommissioning and abandonment, it must have a plan. Again, I told us that in the PIA there are several requirements for plans: environmental management plan, remediation plan, decommissioning plan, field development plan, so many plans. Are you with me so far? So first of all, develop a plan. Submit it to the commission or the authority as the case may be. This is my plan, or this is the program I have devised on how to go about decommissioning this facility. Among other things, that plan or that program must, I'll give us some of the items. It must estimate the cost of the proposed measure. It must contain details of the measures proposed to be taken in connection with the shutdown of operations and decommissioning and abandonment of disused installations, structures, or other assets used in petroleum operations as the case may be. It must also contain clear descriptions of the methods to be employed to undertake the work program, which must be in line with good international, again, good, why not best, good international practices, industry practices, and environmental development. It must also contain the steps to be taken to ensure maintenance and safeguard where any installation, structure, or pipeline remain disused and in position or are to be partly removed with respect to deep and ultra deep water environment. And lastly, it must contain an assessment of the environmental and social impact of the decommissioning and abandonment. What will be the environmental impact? Are you with me? There is environmental impact when you are putting installation. Now that you are even removing it, you have to assess this thing you want to remove now. Will it affect the environment adversely? All that must be properly assessed before you commence the decommission. If not, sometimes it's even better to leave it as it is. Are you with me? If by the time you are removing it, it will cause more problem, then you leave it as it. I have a cousin who has a bullet in his body. He has had that bullet for at least over 20 years since he showed me. Sometimes to go and do the operation, you may end up causing more problem. Is that also? So the doctor will just say, leave the bullet there and come for x-ray from time to time. Let's just check it, but it's better there and all that. So sometimes if you are going to remove installations and then the implication of that removal is even more expensive than, are you with me?
Yes.
Yes, why not just allow it to remain there? Can we continue, please? Yes, so having submitted the program, the company is also required to consult interested parties, relevant public authorities and bodies. The community where that company has been operating must also be aware of what you want to do. They must be aware of what you want to do. They must be aware of what you want to do. And then you must consult them adequately. It is after that that the commission or the authority, as the case may be, can now approve that program. They can now approve that program upon being sure that there is compliance with relevant environmental, technical, and commercial regulations or standards. You must comply. Again, in the oil and gas sector, we have all manner of standards which the regulator wants to use to benchmark what you intend to do. The oil company remains liable. The oil company remains liable for any liability arising from the installation, structure, or pipeline that he does not remove. So if you remove, okay. If you refuse to remove, then just know that you are likely to bear the cost, the consequence for any damage either to the environment or to life, human life, that may arise as a result of your failing. So what the act says is that where the installation, structure, or pipeline is partly removed, the licensee or lessee shall remain liable for any residual liability arising from the installation, structure, or pipeline that he does not remove. Are you with me so far?
Yes, sir.
So your concession is over. Your 30 years or your 20 years or 15 years is over, as the case may be. You have terminated your relationship with that government. You have moved over to the United Kingdom. You had an obligation to properly decommission the facility and all the installations. You only removed some and kept some there. You are likely to be subjected to ongoing obligations with respect to those installations. So whenever you are bringing an installation and you are planting it in an environment, you have to know that if you do not remove it properly and completely, even when your tenure or your transaction is over, you may still be called upon to bear responsibility to the persons that suffer as a result of that. Now, before approving the program, before the regulator will approve the program for the decommissioning again, it must be sure of certain factors. You want to see section 232 sub 10 before you approve the program. What must he be sure? What must he consider? I will run through them again. He must ensure that considerations and recommendations are taken in the light of individual circumstances. You have to ensure that considerations and recommendations are taken in the light of individual circumstances. You must also consider the potential for reuse, or you must ensure that potential for reuse of a transportation pipeline, together with other existing facilities in connection with further hydrocarbon developments, is considered. This pipeline you want to decommission because this thing is over. Can't another company use it? Tarila, are you with me? Yes, your tenure is over. We gave you a lease of 15 years. 15 years is up. You want to return to your country. But this pipeline has a shelf life of 30 years. It can operate for another 30 years, another 15 years on top. Why will you now dismantle? Because again, in decommissioning, like I said, you have to expend a lot of cost, and it may also have adverse effects again on the environment one way or the other. People may even die. There may be accidents, and there's a different company that has the potential to also export oil that can use this facility. Are you with me?
Yes.
So the government has to consider the potential for reuse of that facility. Number 3, all feasible decommissioning options must be considered, and a comparative assessment must be made in that regard. Before approving the program, the regulator must be sure that all feasible decommissioning options are considered and a comparative assessment has been made. Then the next one, any removal or partial removal of an installation or structure or transportation pipeline must again be performed in a manner that guarantees sustainable environmental development. What is sustainable development? Yeah? You have learned that environmental law in your 3rd year. What is sustainable development? The most basic, widely accepted definition. Yes, Barrister Comfort. Want to say something?
So sustainable development are like things put in place to ensure that the usage of things continue even for future
Generations. Good. So you are using a facility, using a resource with an eye to the present and with an eye also to the future. You don't just squander for just now. The prophet went and met a king called Hezekiah, and then he told him, who were those men that came to you? Where are they from? He said, they came from Babylon. What have you shown them? He said, I showed them everything in my palace. There was nothing I did not show them. I showed them everything. And the prophet said, hear the word of the Lord. In the future, those envoys from Babylon, they will come to your palace and take all your descendants as captives to Babylon. And Hezekiah said, the word of the Lord that you have said is good, for at least there will be peace and prosperity in my lifetime. That is a selfish man. So they say your grandchildren will suffer because of what you have done. He said, the word you have spoken is good. At least you don't concern me. And that is how a lot of our people are. Sustainable development says, no, don't just look at now. Are you with me? look at the future. Use the environment in a way that will not just benefit now and then. I said all of that to bring you to this, that before approving the program, the commission or the authority, as the case may be, must ensure that any removal or partial removal of an installation, structure, or pipeline is to be performed in a manner that guarantees sustainable environmental development. And the next one is that any recommendation to leave an installation, structure, or gathering line in place must be made with regard to its likely deterioration and to the present, possible, and future effects on the environment. So it's environment. So if somebody tells you that the PIA doesn't have adequate provisions for environment, you can, like I told you, you can argue either way. You can argue yes, you can argue what? No. And because there are several significant references to environmental protection, one of which is decommissioning and abandonment. And lastly, in the case of offshore installations and structures, it must ensure that there is consistency with applicable good international petroleum practices. Why good? Why good when we can do best? Is that not a mediocre way of thinking? Why good? Okay, we're almost done. Are you all tired? The weather is okay now. Say the topic is very dry. Very dry. Okay, so what is the role of the regulator in this event? What is the role of the regulator in this event? Please bear with me. We just have 6 more slides, and then you will be out of my face, and I will also be out of your face. The role of the regulator, which is the commission or the authority as the case may be, is to enforce compliance by any holder of a current license or lease, or a holder of an expired license or lease. So if you had the responsibility to decommission, irrespective of whether your tenure or your license has expired or your lease has expired, it is the role of the commission or the authority to ensure that you comply with your obligations in terms of D&A. Are you with me? And so also to ensure that that holder or past holder carries out its remaining or unfulfilled D&A obligations. D&A obligations. In archiving and maintaining the database of installations, structures, and assets, again, the regulator is mandated to prescribe the manner and method in which the data shall be submitted by operators. So another thing, let me just point out, another thing that this act has now done is to provide for the creation of a database of all facilities that are going to be abandoned and decommissioned, and ideally this database ought to be housed in a website that should be freely accessible to all Nigerians. Are you with me so far? Yes. So it is the regulator is to now prescribe the manner and the method in which the information needed to develop this database will be prepared. Now let's talk about D&A in the event of divestment or expiration. What happens when a license expires and the man has not come to decommission? He's thanking God and he wants to now travel to the US. The commission or the authority may recall a license, a concessionaire, a licensee, or a lessee who is responsible for D&A with respect to area that has expired or is surrendered, or a license or lease that he has transferred or divested. Are you with me? So my license has either expired, 1, 2, it has not expired, I've surrendered it to government, or I have transferred it to another third party, the authority or the commission or the authority can still say, okay, wherever you are, please come and fulfill your what? Your what? Obligation. Excellent. Are there questions? Are there questions? Okay, now let's run through the D&A fund. I just have four more slides. I talked to you about the fund. Section 233 mandates the setting up of, mandates the regulator, again, as the case may be, it could be upstream, commission, downstream authority, to set up and maintain a D&A fund, which is to be held. Actually, the obligation for setting up the fund is imposed not necessarily on the authority, the regulator, but it is imposed on the concessionaire. Are you with me? Yes, so the concessionaire will set up and maintain a D&A fund and house it with a financial institution that is not affiliated to it, an independent financial institution, if you may, to take charge of this fund. And I told you, what are you using the money for? You use the money to pay for D&A costs. And if you fail to comply with the plan, then the authority or the commission may pay third parties to carry out your own obligations from that fund. How do we determine the contribution that you are to make to the fund? How do you determine the contribution you are to make? Section 233, subsection 4. Compared to section 79, subsection 2. Remember under section 79? And that will sit up well. Remember under section 79, you must submit a field development plan, which must also detail how you intend to decommission and eventually abandon your facilities or installations and all that. So once the plan is approved, then the plan itself will contain, let's just look at section 233 sub 4, please. Let me read what I have here. The amounts to be contributed to the fund shall be based on the following. With respect to upstream petroleum operations, on the decommissioning and abandonment plan approved by the commission in the field development plan. So the field development plan, in that your plan, you will say, I intend to decommission and abandon this facility at the end of my operation. I intend to spend this amount of money, and so to that extent, I'll be paying this amount to the fund annually for the next 20 years. And if that your field development plan is approved, then you simply comply with the decommissioning and abandonment plan as contained in the field development plan. Remember that the field development plan from first semester is a plan that contains other plans. Are you with me?
Yes, sir.
It's a model of plans. So it has the local content plan, it has the employment plan, training plan, D&A plan, environmental management plan, and all that. So it is under that field development plan that you have the D&A plan, and it is in compliance with that we are able to determine how much you are to contribute. But when no decommissioning and abandonment plans exist, and a field is in development or producing, please listen, the lessee shall submit a D&A plan based on the criteria established in section 2326 of the Act within 1 year of the effective date, which, when approved by the Commission, shall form the basis for the computation of the amount to be contributed by the lessee. The same concept is brought out for companies that are operating in midstream and then in downstream. Are you with me so far?
Yes.
Good. So please, I want you to go and then look up section 232, 234, 232, 234. The plan is to establish the yearly amount to be contributed. I told you you contribute every year, and it is based on a reasonable estimate by the concessionaire of the applicable D&A costs, and then you continue on making that payment. Every 10 years, we could review it. Every 10 years, we could come back to review it, because we could have inflation. If you are contributing 10 naira now, after 10 years, that 10 naira may be useless. So we may say, oh God, no, 10 naira is not enough. Things have changed. The price of fuel has gone up. So now you'll be contributing 50 naira. I don't know if you understand. Yes, so the estimated life of the facility shall be based on the estimated life of the field. So we look at the life of the facility, and we look at the life of the field itself. We look at the period of time for which the safe operation of the facilities were designed. These are all factors that are considered. This thing we're asking you to come and decommission this pipeline. Ideally, it should work for 10 years. So that is the estimated life of the facility, of the installation. We also take into cognizance the fact that your own lease that government has given you is running for 8 years, or is running for 12 years. We'll consider all those factors before we now tell you to be paying this amount of money every year. Are you with me?
Yes, sir.
Good. And we'll review it once in 10 years. So after establishing the fund, the company is to inform the regulator, as the case may be upstream or downstream, within 3 months after it commences production. Once you begin to produce, within 3 months from your commencing upstream, not production, upstream operation, or within 3 months after you commission a midstream operation. So like Dangote now, they have commissioned this facility, even though some people say it will not come on stream until 2024. Some people say 2028. I don't know whether these people are doing us magic and 419. You know, it's only God that will show us mercy. 1 month before our former father, his tenure was over, he quickly began to commission things. Is that also? He commissioned airways. Now they say, what did they say about the airways? Tarila, what did they say?
I think it's fraudulent. They've returned back the airline to Ethiopia, I think.
They wrote it, what a mess. That they went to get an aeroplane from Ethiopia and change the color, paint it. What kind of wickedness? As though you are dealing with goats. In normal, how much?
29 billion.
Imagine. Now Dangote refinery too, with so much fanfare, it's a big talk. They went to commission it. Now I'm hearing that the thing is just at 70% completion. NNPC has even given Dangote, who is now meant to take crude oil from here, refine and sell to us. NNPC has given Dangote an import license to import refined crude. There's not the level of wickedness we have not seen. So within 3 months, please, within 3 months from when you commence upstream petroleum operation, or within 3 months after you commission your midstream or downstream facility, let us know. That's what the law is saying. Are you with me? Yes. Inform the regulator, and after that, furnish an annual statement of account with respect to that fund. Let's see annual statement of account. And I told you that the fund is to be used exclusively for the purpose of decommissioning and abandonment of structures and facilities. Okay, so the plan is to be funded in whole or part. If the plan is to be funded in whole or part by third parties, and in the event that, the plan is to be funded in whole or part by the applicable third parties, that is for PSCs, production sharing contracts, and contributions are eligible for cost recovery and shall be tax deductible. So the companies are allowed to deduct these funds for purposes of cost, for purposes of tax. So I think we can stop here. When we meet next week, we will look briefly.